guys, thanks again for watching. This week's video is a conversation with a friend of mine, Pete Adams. He's an IP attorney, intellectual property. If you enjoyed this video, again, drop a like, comment, subscribe, etc. This should be the first of several conversations that I'll be having with different types of attorneys, financial advisors, accountants, bankers, that kind of thing. Got a few other interesting ones lined up, so if you enjoy this one, let me know. Give me any thoughts of other folks who you would like to see this kind of a conversation with. And again, like, subscribe, etc. My website at ryanreifer.com, or you can reach Pete at info@peteadamslaw.com. Thanks again for watching.
There we go. Let's see if we can get started. Pete, thanks for coming in. Well, not coming in. You didn't come anywhere. You're doing it from your couch or whatever. But thanks for hopping on the Zoom to talk about this today. I've known Pete Adams for a while. We worked at the same firm for very briefly, but have kind of stayed in touch since then. He's a good guy and a good IP lawyer here in town. And I wanted to get him on camera and kind of get his perspective on some of the IP issues and questions that he gets. And Pete, I'll tell you some of the questions that I get and kind of the way that I answer those. So if we can get started.
Okay, thank you very much for inviting me, Ryan. I really appreciate it. I have about 5 years of total experience in patent and trademark. We started over at the same firm. I started working there in 2016, but I started my own practice approximately 2 years ago in early 2019. So I've got about 2 years of solo practice experience in patent, trademark. I do a little copyright as well.
Okay, right on. Well, so one of the questions that I get is, what is intellectual property? And the way that I explain it, I'm sure you'll have a better method of explaining it, is I tell people there are kind of three buckets, right? You have copyright, you have trademark, and you have patent. Copyright is art. It's fairly cheap to register. It's what, $50, something like that, to register one. The folks at the Copyright Office, copyright.gov, are generally pretty helpful. It's for works of art, be it music, movies, visual arts, that kind of thing. Trademarks are logos, right? Like the Nike swoosh or the McDonald's M or the Starbucks mermaid or whatever. It's a thing that is used to distinguish one product or one service in the marketplace from others. Those are, at least I tell people, those are a fair bit more expensive than a copyright, that you're probably talking in the hundreds of dollars to maybe thousands of dollars, depending on a whole lot of factors that Pete's a lot smarter about and can give more detail. And then the kind of big fancy one is patents, and that's, if you invent a better light bulb or a better way to fry an egg or some sort of highly technical thing, that you can obtain a monopoly on that for a certain number of years, and you have to file that with the Patent and Trademark Office, and it's much more technical, much more engineering kind of thing, and most attorneys who don't have an engineering background actually cannot practice patent law, whereas I could go do copyright or trademark practice. I could not do patent practice, whereas someone like Pete could. So Pete, how am I doing?
That's a perfect explanation of the basics of the three major areas of intellectual property. So, and actually, copyright is so inexpensive, so that if you have a group of art, like you have a collection of related pieces, let's say, a number of songs, or, you had drawings that related, you can actually lump them together in into one group filing, and it's only $85 to file up to 10 copyrights within one application. And so it's very inexpensive. there's not a lot of substantive review really much at all by the Copyright Office. So you have a very low likelihood of getting a rejection, whereas in trademark and patent, there's a much more substantive review process by the office. And, you're more likely to have to deal with office action rejections. In terms of copyright, it's not, you actually establish copyright protection as soon as you produce and publish a work of art. So it's not necessary to file a federal copyright application, but if you ever want to pursue legal action and file a suit and prevent someone from using your work of art, then you definitely want to have that federal copyright registration. So similarly, there's what we know in trademark law, there's common law trademarks, which most people have heard of. So as soon as you start using a mark, first in use, you've got protection of that brand, of that logo, for example. You're the first one to conceive it and start using it in commerce, then you have common law trademark rights. The reason people file federal trademarks, and it's extremely valuable, is you can accrue much greater damages if you ever go to a lawsuit, because you're providing constructive notice to everyone nationally that, hey, this is the mark, these are the goods and services that I use this particular brand or logo for, and you essentially put anybody else on warning to prevent them from using it. And when you file that trademark application, you're also saying first in use. So it's not just based on the filing date. It's not first to file. It's first in use. So let's say you file a trademark application tomorrow, but you've actually been using that mark in commerce for a year or two. Well, you can backdate it. And when you file the trademark application, you say first in use this date. And then if you ever have to prove that, well, hopefully you've got sales receipts, or you've got proof of use on a website where you have a dated a timestamp showing that you actually use the mark in commerce. So it's still highly beneficial to file a trademark application, just in terms of the type of damages you can recover. Now, a trademark application is not beneficial at the federal level for a lot of companies, especially smaller companies. For example, a local company that sells, or for example, a company, I guess, that would, like a car repair company, or like local companies that only provide goods and services to like areas within Texas or areas within the city. They're not going to be entitled to federal trademark rights because it's not in commerce. What they're doing is not in commerce amongst the states or international, so they won't be able to get federal trademark protection. However, it's only $50 actually to file for state trademark protection in Texas. It's not as commonly used, and a lot of people don't end up even filing state trademark rights, especially if they want to go later and sell goods or services outside the state. They just do the federal trademark. But it's an option if you're a local company and you want to establish like a state trademark rights, and you're worried about somebody copying your product name or your company name, for example.
Yeah, that's interesting, because I had heard about that from the perspective of don't bother if you're just local, just do the state trademark filing, and it's way cheaper. It's there's you're not operating in Oklahoma or Alabama or Tennessee or Washington or whatever anyway. But what you're saying is that you would actually be unable to get a federal trademark if you're not engaged in commerce over a state line.
Yes. Now, it is possible to get past the trademark application process. For example, if the examiner, accepts your specimen, you submit a specimen showing, hey, I'm selling this good or providing this service. And let's say, he doesn't look closely at it and see whether or not it's actually available outside the state of Texas. You may get approval, but if you ever try to go enforce that, well, it'll be an unenforceable federal trademark, because somebody else could use that exact same logo or brand for a similar group of services. If they use it in, let's say, the state of Washington, or they use it in New York, and you're only providing those goods and services in Texas, well, then you can have concurrent use. I mean, there's no likelihood of confusion of, you're going to a car repair shop in San Antonio, and there's another car repair shop in New York that has the exact same name. So,
all of the shops that are, AAA car repair, A1 car repair, all the ones that have sort of named their businesses to appear at the front of the phone book, right? And I'm sure there's
exactly.
100 of those in every city.
Definitely. Yeah, definitely. And what was I was going to say one other thing in regards to trademarks. One benefit though of the federal trademark process is you can actually apply based on intent to use. So there's the standard trademark application. You've already got it in use. You're filing it, and you receive protection. And within average of 6 months, you should have a federal trademark registration. Now, another process is known as intent to use. Now, that's when you have a proposed brand or logo, but you're not yet using it in commerce, but you plan to later. Well, you want to protect that name early, so you file it, and you file it based on an intent to use. And as soon as you file, that date establishes priority. Even if some other company goes and starts using that name or logo before you actually use it, you've got that first to file priority date. Now you can keep, once that, let's say you get a trademark application approved on intent to use after 6 months. Well, then you have 6 months to file a statement of use showing that you're actually using the mark in commerce. Now your goods are available for sale. You submit that specimen, and then now you've got a federal trademark registration. Now, if you still can't use it for a year or two down the line, you can file up to 5 extensions. So every 6 months, you can essentially file and pay a fee and extend it. So you can hold a trademark name for a couple years before you even start using it.
Wow. So you get the initial term plus 5 6-month extensions.
Yeah, you've got so like actually you could go up to 30 months or 36 months. You can essentially hold the name and prevent anyone else from trying to use that, or at least prevent anyone else from trying to file that name. So like it'll get suspended. For example, if someone else tried to apply using that name, the examiner is going to do a search and says, oh, this one's still pending. Your application's still pending. We need to suspend this other application until we determine whether or not this is going to register. So I've seen some companies do that. They protect a name. They file a bunch of trademarks. You probably heard of it. They're like, hey, I'm going to protect all these different names. And then they're calling them like squatters. They're going to hold it and see whether or not they can use it later or sell it to someone later. So that's actually fairly common, this intent to use trademark application.
Okay. I have heard of trademark squatters before, but I didn't fully understand that was the mechanism by which they do that. That's interesting stuff.
Yeah. You want to talk about patent a little bit now? Sorry, I just spent
yeah,
trademarks there.
Please.
Okay, well, with patent law, you've got a couple of different patents that you can obtain. One of them is a utility patent, which is exactly what you described. It's you're patenting how something works, an idea, a function, a system, an apparatus. You're patenting an idea and an application and how it functions, the utility of a device. Another example of a patent would be a design patent. A design patent protects the ornamental appearance of a product. So let's say you had a piece of furniture, for example, like a shelf with a couple of key holders and a mirror. Let's say you just had some unique piece of furniture, and you obviously can't get a utility patent for it because it's not providing any novel function or non-obvious function because it's already been, people have had these for hundreds of years. But you can obtain a design patent based on how it looks, and your design patent will only protect your product, from infringers who copy that exact same design, or they copy the design and only make slight modifications to it. So obviously there could be, if you do a search on Amazon for key holders or a furniture search on there, you're going to find hundreds and hundreds of different pieces of furniture. Now, a lot of people don't realize that, hey, you can file a design patent, and you can, this is very useful on Amazon sales, especially because you have so many third-party sellers that try to come on there and, sell your exact same product. And then you've got 20 competitors selling your same product on Amazon. Well, if you don't have any sort of IP protection, there's nothing you can do about it. But a number of my clients have actually filed design patents, and they're very, very inexpensive, and you have a much higher probability of success than a utility patent. So on average, we're looking at the statistics, you're talking about over 90% of design patent applications get approved. And actually over 80% of them get approved without even a rejection.
And so, what is it for utility patents, more or less?
Utility patents, it ranges. There's a lot of different type of utility patents, but on average, the last time I saw was between 50 to 60% get a final decision, or 50 to 60% get a grant within 2 to 3 years. So I think the average pendency of a utility patent application is around 25 months. So a lot of these ones, that get issued, okay, yeah, you got let's say you have a 50% or 60% chance of getting the patent granted. Well, you're still going to have to wait 2 to 3 years on average to even get that grant. As opposed to design patents where, yes, it takes a while for the office to review it, but I've had design patents issued in less than a year. It can vary. It's usually between 12 to 18 months you'll get a response on a design patent. Not only that, a design patent does protect your invention for 15 years after the date of the grant. Utility patents.
Form versus function, right?
What's that?
This is kind of form versus function.
Yeah, exactly. So, I mean, utility patents are way, way more valuable in the market, obviously, because you're protecting a lot of different embodiments of your invention. Or let's say you've got a software application and you want to protect anyone from solving the same problem that your software application solves. Or let's say you've got a system or a device, and it solves some particular problem, and you want to prevent anyone else from making a similar product. Even if their product doesn't look anything like it, they'd still be infringing on that utility patent that protects the function. If it functions in substantially the same way, then you're infringing. So that's why utility patents on a whole are much more valuable. It's just not everyone has the ability to obtain utility patents.
Right.
So they're both patents are extremely useful. And actually companies like Apple and Samsung hold hundreds and hundreds of design patents. So they obviously do have a lot of value. And there was a case, Apple versus Samsung, a few years ago that had to do with design patents. So I think people undervalue design patents just because they have a reputation of, oh, well, all someone has to do is make a slight modification and they can sell your exact same product. Here's another thing that people can do: file a few different design patents. Spend an average of a little over $1,000 or so on each design patent application. File 3 or 4 where you're protecting a few different modifications of that design. Well, on average, you're still spending less than you're going to spend on a utility patent application.
Right.
So you protect like 3 or 4 different embodiments. You can get protection earlier. And so it is an option. And not only that, you can have both applications. You can file a utility patent application, and you can also file design patent applications that are based on that utility filing date. So you've got a few different options. If you never get a utility patent out of something, well, at least you've got some design patent protection. So there's a lot of different options.
Right. To your point earlier about the shelf, I mean, and I want to come back to that because we briefly glossed over something that that I know about and you of course know about. But can you talk for just a second about this question of novelty and why a shelf or a couch or a chair or whatever, no matter how clever, would not be eligible for a utility patent?
Well, a couch performs the function, for example, of people sitting on it and laying on it, and it's a support for a person to sit on, which is not novel. I mean, that concept has existed since couches were first invented. Um, you can't protect something that's either not novel or non-obvious. So there's a couple of requirements. It needs to be novel, so it needs to be a new idea, but it also needs to be a non-obvious idea. So let's say you had let's say a couch with a feature like where you can extend it and raise your feet and your legs, and it's one of those like it's retractable couches.
Right.
Yeah, well, but let's say somebody first came out with the idea for a chair that had that same mechanism. So let's say someone invented the chair, that could recline, a reclining chair, and it used the exact same mechanism. And then later somebody had an idea, hey, let's take this mechanism and put it in the couch, the exact same mechanism, but we're going to put it in the couch. Well, a patent examiner could say, well, if you combine this idea of the chair mechanism and then you put it into the couch, it's a obvious modification, an obvious improvement, and it wouldn't be entitled to a patent protection. So it's a complicated process to get utility patents, because on average, over 80% are going to get some sort of rejection. And a lot of times it's that obviousness. And a lot of times it's hindsight. Oh, the examiner's like, well, if you combine these three references, your idea is obvious. And I'm like, well, you had to pull three references, one from 50 years ago, one from 2 years ago. It's not really obvious, but it's an argument that goes back and forth with the examiner. And that's why you have a patent attorney to come up with these arguments as to why your product is a non-obvious improvement over what's already out in the field.
Right.
So utility patents are just it's a more complicated process.
But a design patent completely sidesteps the novelty and novelty and non-obviousness.
Yeah, exactly. It's like the only way you get rejected is if it's very similarly shaped to something else. That's the only time it's going to get rejected. So if you try to file a design patent application for this couch, but it looks almost identical to another couch, then you're going to get a rejection. But it's very rare for that to happen. One important thing to note is that, and actually one of my clients just is about to file 4 different design applications. They're a big Amazon seller, and they want to do 4 design applications. But I noticed that when they first put it on sale, it was in June of last year. So they've got only a 1-year timeline. Once you put out a product, you publish it, or you make it available for sale online, you've only got a maximum of 12 months to file. If you do not file a patent application within that 12 months, you will not be able to get protection at all.
So it just your ability to protect it just disappears. You have to file.
Exactly. You have to file something. It could be a provisional application, which we haven't brought up. Provisional patent applications very inexpensive. I mean, the fees right now for a provisional patent application for a small entity, small company, $150 of USPTO fees. For an individual who makes less than $210,000 per year adjusted income, which is a large percentage of the population, it's only $75 to file a provisional. And provisionals are very useful because you've got your idea. Maybe it's not refined yet. Maybe you've still got you want to test out the product. Well, you can do this provisional filing, and then you've got 12 months after you file that provisional to decide whether you want to actually do a utility patent non-provisional application.
So that extends the timeline basically. So if I come out with something, I'm using it for 6 months, and I'm not sure whether hey, this new piece of software or whatever is useful, but I don't know if it's useful enough that it's worth paying somebody thousands of dollars to go get a patent.
Exactly.
I file my provisional. That gives me another year. I get to save my place in line, and I can kind of see what the product does in the market and see if it's worth it.
Yep, exactly. And then you can also file multiple provisionals in that 12-month time frame. Let's say you came up with a modification to a prototype, but it wasn't covered in the initial filing. You can file another provisional for another $75, let's say. Oh, here's the modifications. This provisional makes reference to the other provisional. And then so now you've got, this filing date. And then when you go and file a non-provisional application, you claim priority to whatever provisionals you filed in that past year. And then they're all lumped together within that same, now each one of those prototypes is going to have a slightly different filing date for whenever you filed it, which will only really matter if somebody filed before you. Before that idea, before you filed whatever particular idea it was, if someone else filed, then they could predate you. But the provisional is a great tool. Very great.
So if I file a provisional and then you file a provisional and then I file a provisional with a modification, that modification gets to count the date of the first provisional that I filed.
No. That modification, the new matter that you added will have the new provisional filing date. But
Okay.
if it's built, everything else you include it. So your next provisional, you want to include all the things from the same provisional. So it's going to be like a copy, almost like a copy paste of the old information. And then you're going to put an add-on at the bottom. You're going to be like, well, here's a new embodiment that I've come up with. And then you file that. So that, yes, that new piece of information will be brand new, but everything else will still be entitled to the prior date.
Got it.
So it's a little complicated, and like the nuances of doing all these different filing dates, but it's extremely important in evolving technologies to file things as quickly as possible.
Yeah.
Especially in technology.
Yeah, absolutely. Okay. So you want to move on to the second question that I had for you? Or you have anything?
Sure. Yeah. Sorry about taking a lot of time on that.
No, you're doing good. This is very useful stuff. So the second question that I had was, suppose that I'm a small business or a startup or some kind of, I'm the little guy, and I get a letter from the big guy saying that that I'm infringing someone's IP, whether it be a copyright or a patent or whatever. What's my what's my game plan? What do I do?
Well, I would say the first thing, don't immediately respond to it, and don't admit any guilt. First, I would definitely talk to an attorney, an IP attorney, share with them the cease and desist letter or the notification of infringement. So you're talking about more of like a cease and desist type of letter, like, hey, you need to stop selling this because you're infringing. We plan to immediately file a suit against you.
Sure. I mean, either one, right? I mean, yeah. I'm talking about a small business who doesn't really have a lot of experience in the IP arena, being suddenly told, hey, you're stepping on our IP. And,
okay. Well, yeah, I've got actually a few examples of that from my experience, and actually a lot of them were just fraudulent cease and desist letters. Like they were accused the client of infringing on a design patent, or they even accused of infringing on copyright, and the products weren't even identical in a side-by-side comparison. That's the test for design patent infringement, side by side. So I evaluated, I put their patent, their published patent, and then I looked at a side-by-side comparison of my client's product. And I'm like, okay, look at all these differences in features here. They do not look substantially similar. So I don't see infringement. And I responded to the cease and desist, and then I never got a response back. And so it's like a lot of times there's bullying involved in a lot of these cases. So you really got to be cautious of it, where and it happens a lot on Amazon sales as well. They'll have a company that'll be a big name brand company that has a lot of different products on Amazon, and they'll file IP infringement claims on there. And all you have to really do on Amazon is correctly fill out the form, and you could make reference to some patent Amazon, in a lot of cases, won't substantively review your claim to
Hmm.
see if it has merit. They're just going to look at it and say, uh-oh, well, they'll notify the seller that is accused of infringement and be like, well, this other company says you're infringing on their patent or their trademark. And they'll say, hey, well, you need to remove, we're going to temporarily remove your listing and you need to sort this out with the other company. And in some cases, when you respond to that other company, they won't even respond back. So their goal is essentially to get you offline. Amazon doesn't want to resolve the disputes because they don't want to be held potentially liable and lumped in because they make a commission off of all the sales.
Of course.
So they're not going to want to be involved in deciding. They don't want to be the judge. They don't want to be the arbitrator for it. So they tell people to settle amongst themselves. But a lot of times the company that filed the infringement claim won't even respond. Their goal is to try to get as many listings removed as possible. So that's kind of that's an example of where it was a fraudulent claim of IP infringement. Now, in some cases, they're very legitimate. And then that's when you still need to hire an attorney and have them evaluate it. If it's a lawsuit, you definitely want to find a experienced IP litigation firm to deal with it because litigation is extremely expensive. If it's just a cease and desist, then you definitely just want to have an attorney evaluate it and see whether it has merit. I've responded to a lot of different cease and desists, and I would say more than half of them I found that didn't have merit. So their claims were invalid, and I think they were unlikely to win in a civil suit, and so their approach was to send a cease and desist. Now they didn't want to. That's the least expensive method for them to just pay an attorney to send this short letter. Now, if they were to file suit and go to litigation, it would cost thousands and thousands of dollars.
Right.
So the cease and desist, don't immediately respond to it. Hire an attorney. Obviously, the same thing with an IP litigation suit. Definitely want to hire an IP law firm or attorney.
So are you required to send a cease and desist before you file a lawsuit, or can you?
No, definitely not. And actually, a lot of cases, they'll say, well, if you really want to file a lawsuit, why send the cease and desist? Just file the suit. The cease and desist is a waste of time. If someone's infringing on your product, for example, or on your patent, just go ahead and file the suit. That gives them even less time to prepare.
Right.
It's like, why would you want to send them the cease and desist? Then they're going to hire an attorney and then evaluate it. If you're the person who's filing the suit, you should just go ahead and file it if you have a strong merit to the case. Now, if you want to save costs and not spend thousands on the lawsuit, then you try the cease and desist method.
Right. And who knows whether the person that you're going after has enough to justify those fees.
Yeah, exactly. And a lot of times it's bigger companies going after smaller companies on these cease and desist and these claims of IP infringement.
Yeah, interesting. So they just have some law firm that sends out hundreds of these letters, and they hope they get a few people to take their products down and call it a day.
Exactly. Yeah. And actually, I had 2 separate clients within a month get similar cease and desist letters from the same big company. And the big company, I responded to them, and they never responded back to me.
Interesting. Okay. Any other advice for somebody that is accused of IP infringement before we move on to our next?
No, I think that pretty much covers it.
Consult your friendly neighborhood attorney.
Exactly.
Okay, so I've worked a little bit with licensing agreements, but I wanted to get your kind of sense on, if let's say you have a client who has a nice piece of IP, whether it be a patent or whatever, and how do you decide whether a licensing agreement makes sense or whether producing it yourself makes sense?
I would say, based on cost, how able are you to actually mass produce a product? If you've got a great idea, you've got patent protection on it, and you want to produce it because it's going to make a lot of revenue, but you don't have the resources necessarily to produce it, then you've got to look at alternatives like, well, what if I licensed it to another company that already has the capacity to mass produce it? Would I make more in that than I would be trying to get it manufactured on my own? So you've got to kind of weigh the costs and benefits of licensing it. So there's a couple of different forms of licenses, I'm sure you're aware of. There's like non-exclusive, and then there's also exclusive licenses.
Right.
So for the licensee, obviously they want to have an exclusive license so they want to be the only one able to sell it. Now the royalties are obviously going to be higher that licensee has to pay because they don't have to compete with other companies in the market other than potential infringers that are of course going to try to sell a similar product, but they don't have to worry about let's say you had a non-exclusive license, and then the owner of the patent licensed it to like 8 different companies, and they're all paying them royalties. Well, then they're all in competition with one another.
Right.
So obviously the non-exclusive license is going to be way more valuable to the licensee. In terms of the company deciding to do it, it's a negotiation process between you and whatever company you're going to license it to. You want to make sure that you get fair royalties. You want to make sure there's a method of paying you. You want to make sure that the contract is done. So you definitely want to file or hire an attorney to do it. You don't want to draft your own. You don't want to just take a template that you find online on a website and just, hey, okay, yeah, these royalties seem fair. Let's just take this contract and put it in here, and all right, now we got it in contract. Because I mean, your likelihood of being able to enforce that, and you have no idea even if it's valuable or not. So there's a few different benefits. If you can, a lot of my clients actually they hire manufacturers over in China to produce their products. So they have those connections, and if you have those connections as a manufacturer or as a patent owner, by all means do that. Because if you can produce a product for very, very low cost, then you might as well do that. But if you can't, then a licensing agreement is definitely another option.
Right. So for the China route, you don't have to license to them because they're producing it for you. So
yeah, it's just like non-disclosure. They're just producing it, and they're not going to be selling it. So you make them sign an NDA, and you make them say, okay, you're only going to manufacture this and distribute it back to my company. You're not going to make it and sell it to anyone else.
Right. And good luck enforcing one of those in China anyway.
Exactly.
Okay, so another kind of area that earlier this year I wrote a little blog post about some works that had come into the public domain on January 1st, 2021, and the one that I remember was The Great Gatsby. And it entered the public domain and lost copyright protection. I guess over the next few years, there is another batch of those works scheduled to enter the public domain each year. So for any of these listeners who have no idea what the public domain is, how would you explain the public domain?
I would say the public domain is, available to members of the public. Once a copyright doesn't have protection forever, once those intellectual property rights expire, they become, eligible to use by the general public. I'm not,
including commercially, right?
Yeah, exactly.
Yeah.
I don't have too much experience in this particular area. Like, not many clients actually even ask me much about the public domain.
Okay.
I've gotten some questions about fair use, which is another question you may have. But yeah, in terms of public domain, I actually haven't had a single client ask me about that before.
Really?
Yeah.
Okay. Well, I guess
Sorry about that.
no problem. Yeah, so I guess let's talk about fair use then, right? If I if I use a what is it, an artistic or a commentary or a referential, I use someone else's intellectual property as a part of my other work, then that's okay.
So if you're using it for strictly educational purposes, informative purposes, and you're not using it for commercial use,
Right.
and you're not using it, to benefit your company or, to obtain a profit, then it is protected under fair use. A lot of times it's a balancing act, like it's to the degree and the type of work it is. So let's say it's a news article or a factual, piece of information that you're using. Well, you're more likely to be able to claim fair use over that. Whereas if you use a creative expression like, a song or a piece of art or something like that, then you have to be very, very careful that you're only using it for non-commercial purposes. So it's really a lot of times it is debatable, and it's a fine line. Well, is this commercial or is it non-commercial? If you're providing a presentation, and part of the presentation you mention, okay, if you want further information, you can contact me at this phone number. It's really like, was the majority of the presentation to inform, or was the majority of the presentation to lead someone to hire you, or to lead someone to use you for your services?
And if it was the latter, if it was to induce them to hire me, then
Mhm.
maybe using other folks' IP in that presentation is not okay.
Exactly. Yeah, I would not do it. I'd be very careful.
Yeah. Whereas if you're say I don't know, a professor in the business school and you're teaching a unit on Coke versus Pepsi, you can put their logos up on the I don't know if they even have overheads anymore, but the projector or whatever, no problem, right? Because it's
Yeah, definitely. There should be really no issue if it's in an academic setting.
yeah. Okay. Well, I think we're getting close to 12 here. I don't want to keep you too much longer. Um, anything that you want to talk about that I missed? Anything that you wish I would have asked you about?
Did you mention anything about the poor man's patent?
Oh God, thank you. That's so this is an urban myth that I have been asked about. And my understanding is that it used to, many years ago, maybe it would have worked, but nowadays it does not. And you can correct me if I'm totally off base there. But the way that it works is I have an idea for a better light bulb or whatever. I do my patent drawings and I mail it to myself, and I rely upon that postmark date as evidence that I invented the better light bulb as of June 2012, right? And I can thereby accomplish a patent and accomplish evidence that I invented it way back then without engaging an attorney, and save a whole bunch of money. But that doesn't work, right?
No, you're right that it actually used to work, but back in March of 2013, the US shifted from first to invent to first to file. So back when it was first to invent, you could swear by a reference. So let's say you had some drawings or you had an envelope dated and time stamped. You could swear that you were the first to invent if in a proceeding someone else filed before you. You could backdate and swear to the reference that you came up with the idea first. Now, ever since we moved to first to file, the poor man's patent doesn't exist. So file the provisional. I mean, worst case scenario, you file the provisional yourself for $75 or $150. I highly recommend hiring an attorney because you want to provide as much detail and drawings as you can. But the poor man's patent idea is definitely a myth. You really should just pay the small amount of money to file a provisional and to protect yourself.
Okay. Okay. Well, good information. And thanks again for spending your time with us, Pete. I certainly appreciate it.
Thank you, Ryan.
Look forward to getting a beer with you once COVID finishes up.
Oh yeah, definitely. And one other thing I wanted to add on the patent process, because there's a lot of information about patents. So utility patents, you're talking on average, you're going to spend 4,000 plus on a utility patent application. In terms of also, responding to office actions, because there's most likely going to be a rejection. Then you got to pay the issue fee. There's a lot of fees along the way. Not only that, you got to pay maintenance fees down the line. So utility patents are expensive, which is why I recommend to my clients, if they're unsure if their idea is really new and not obvious, they do a patent search. Now, patent searches will run, some companies will do patent searches, the basic. They won't even have an attorney do it. They'll just punch in whatever keywords you give them. You'll give them a vendor disclosure, and then they'll just punch in a bunch of keywords, and then they'll give you the search results. That'll be a few $100. But if you hire an attorney to review it, even if you're spending $500 or so on a patent search, if the patent search reveals other ideas and other publications that are very, very similar to your invention, well, then you don't have to waste all that money going through the expensive utility patent application process. You could save potentially thousands. Maybe you can modify your own idea. Well, this exists, but what if we did this and we changed it around a little bit? So I think the patent search prior to filing a utility, provisional, I wouldn't worry about it. Design patent, I wouldn't spend all that money on doing a detailed patent search. But for utility patents, that patent search can be a very effective cost-saving tool.
Yeah, interesting. Because all I have to do is take my $500 or whatever, and then I know whether I'm kind of sunk from the get-go.
Exactly. Yeah, and then you can say, okay, well, that idea, but I've got a few other ideas. A lot of people I've talked to, they have 3 or 4 ideas. Well, maybe 2 of them are already out there. Maybe they didn't get marketed, so you've never heard of it. Like somebody had an idea 10 years ago, but there was never any useful product that came out of it. So, but the problem is you'll never be able to obtain a patent for it because that publication is already out for the world to see, so no one can copy that same idea.
Is there a lot of stuff like that out there on the patent? What is it? The patent registry, or I assume it's the patent registry. Is there
USPTO expired patent applications?
Well, yeah, or not even necessarily expired, just stuff that folks file and then maybe they get the patent on it and never use it, or maybe they file the application and abandon it, or what? Is there? It sounds like there's quite a bit of that out there, right?
Oh yeah, you're talking probably a few million. In terms of percentages, if only 50 to 60% or so of utility patent applications are granted, then you're talking nearly half of them go abandoned at some point because they either they don't want, they've gotten rejected by the examiner and they don't want it to they just don't want to keep spending any more money to try to argue it, or along the process they say, well, this product that we already started to sell while this patent is pending is not selling well, so we're just going to abandon the patent application because it's not worth it. So there's a lot of reasons why things get abandoned, but once those are published and out there, that they're free for anyone to use. You could use that exact same idea. That's that's essentially like fair use once it's published. What's that?
Whether the patent was granted or not, or
yeah, exactly.
I could file an application. Perhaps I would have ultimately prevailed, but I just abandoned it for whatever reason. Then that thing that I filed is now part of the. I guess it wouldn't be public domain because we're not talking copyright, but it's now free for anyone to use.
Exactly. And sometimes cases like that too, where patents will expire because people don't want to pay the maintenance fees. Those maintenance fees add up every 4 years. So, in order to maintain your patent rights, you need to spend a few $1,000s to maintain it. And somebody's like, well, our product really isn't selling that well, so let's just let it expire, and then you let the patent expire. One thing people you have to be careful of though is sometimes applications will go abandoned unintentionally, and they can revive it. So there is a way, a petition to revive. If, like, let's say the inventor was, God forbid, like in a hospital or in a coma for, X amount of time, and he wasn't able to pay his maintenance fees, or he wasn't able to respond, he wasn't able to pay the attorney to respond to the rejection, that can be revived. It's called unintentional abandonment.
Is
So
there any
you do
kind
have
of
to be
time limit
careful.
on that?
What's that?
Is there any kind of a time limit on that?
No, believe it or not, there is no time limit. So I was just talking to another patent attorney. He's like, "Oh yeah, I had this inventor with this idea. He had an application. It was a pretty good idea." And he said, "Well, I didn't hear from that guy for I haven't heard from him for a couple of years. But let's say he was just unavailable, or for whatever reason, he came back and he was like, hey, whatever happened to that patent application?" There is a way to revive it. I've never seen it at that long of a timeline. I haven't seen it more than like 6 months or a year.
But if you
So
had a good reason that you could show the USPTO, then
yeah, you just have to swear by the reason why. Hey, you're out of the country, or you're unavailable to to respond, and that's the reason why it went abandoned. So it's very rare for years later something to get revived, but it is possible.
Yeah. So don't overcommit to that new abandoned patent application.
Yeah, exactly. And the thing you have to be careful about is if those applications are still pending, you do not want to go out and sell a product that could potentially infringe, because, I mean, there's a chance that patent gets issued, you have no idea, and then, well, guess what? Then you're infringing on that patent.
Yeah. Because the patent would be granted as of the date it was applied, right?
That would be when the 20-year timeline begins, is when your first during the application date. That would be when the 20 years begins to run. But you're not actually, you get patent rights at the time that it's granted. That's when you can first file for patent infringement. If your published patent, this is what they call like patent pending, and people are like, well, can I sue somebody, and file suit if I have patent pending? No, you can't file suit. But if you have a pending patent application, it's published online. So 18 months after you file something, it's going to get published and available. If those patent claims that you filed, if they don't change significantly, and those are the ones that get granted, if the ones that are granted are the ones that are available to public, then you can actually potentially get back damages. So if you send a letter, hey, cease and desist, we have a pending patent application that we expect to be issued. If you notify someone, you can actually get some back damages, so long as the application that's published is almost substantially similar to the one that gets granted.
But you have to tag them with a cease and desist in order to get that.
Yeah, you have to notify them. I mean, it's unlikely, because if it's just a published patent application, then it'd be very difficult to get any sort of back damages back to when it was first published, because as another competitor, you have no idea if that patent's even going to get granted or not. But if a company sends out a warning that they see, hey, this is a potential infringer, then you've received that notice, and so there's a good chance that you're going to have to pay even greater damages, not just from the date the patent's granted. You'll have to go all the way back to whenever you received that letter.
Yeah. That's a big check, probably, in a lot of cases.
Yeah, exactly. Thank you for having me, Ryan. I really appreciate it.
Yeah, no problem, Pete. Thank you for coming on. This is super useful. And you've certainly taught me a few things. So again, thank you. And we'll have to do it again sometime.
All right, I'll talk to you soon, Ryan. Appreciate it.
Thanks, Pete.